All right. Court of Appeal in the 6th District of the State of Florida is now in session. Honorable Mary Alice Nardella, Judge, presiding. All persons having business before the court are drawn near to the attention of the court. And God save the United States of America and the state of Florida. Honorable Court. Just look at the phone, sir.
Good morning. Welcome to an oral argument session of the 6th District Court of Appeal. We have two cases on our docket this morning. But before I call those cases, let me introduce myself. My name is Judge Mary Nardella, and I'm joined today by Judge Brian Lambert, as well as Judge John Scott. The first case that we will hear today is Advent Health Systems versus C. Raymond McIntyre. And that case is number 23-722. Each side will be given 20 minutes to argue. It will be broadcast live streamed on YouTube. We have saved typically 5 minutes for rebuttal for the appellant, but that can be
Good morning, may it please the court. I am Tom Wilkes at the Orlando office of Gray Robinson. I'm here with my partner, Christy Hatcher-Poland, representing Advent Health Systems Sunbelt Inc., which does business as Advent Health, and we use that shorthand. We will certainly want to do the rebuttal of 5 minutes, so thank you, Your Honor. The issue in this case is, or this case will decide whether the medical office building, which is next door to the Advent Health Hospital in Sebring, Florida, is subject to property taxes or is exempt from property taxes. The trial court issued a summary judgment deciding that the medical office building is subject to property taxes, and we've appealed. There were no facts that were in dispute, and this court, of course, has de novo review of the matter. The legal issue is simply whether Advent Health has equitable title of the building. The parties agreed to that. Legal title is, yes, sir.
Do you agree that the ambiguity resolved against the taxpayer?
I'm sorry, Judge, I have to apologize. I'm hearing impaired. If you could use your microphone, that would help me enormously.
Do you agree that any ambiguity could be resolved against the taxpayer?
That is the case law, yes. Yes, sir. Can there be two equitable owners? No, I have not seen any case that says that you can have more than one equitable owner.
So when we talk about sufficiency, in a lot of cases, that it has to be a majority of a person.
Yes, ma'am. Or other cases like the First Union case in the 5th District Court of Appeal, one of the older cases, Judge Winifred Sharp said there has to be sufficient indicia of ownership. She didn't necessarily say it had to be a majority of just a numerical weighing of the burdens and benefits.
If your client was the ultimate would the remedy be a remedy foreclosure or would be a remedy?
Our client, well, first of all, Advent Health has paid all of the taxes. If they fail to pay the taxes, the remedy under Florida law, if that's your question, the remedy under...
If they were to fail to make payments, they make rental payments right now.
Oh, rental payments, yes.
What would the REIT's remedy be if there was a failure to pay rent?
Well, as I recall, under the office lease, the building landlord could evict Advent Health and bring in other tenants and lease out the building that way.
Why should that not be an issue of ownership that goes against Advent Health if they were to be evicted instead of foreclosing?
In isolation, Judge, it is. But that goes right straight to the point that all the Florida courts, the Supreme Court and all 5 of the other districts have all ruled in at least one cases, some of the districts in several cases, that the courts and the property appraisers are not to look at the form of the ownership. They're to look at the entire substance of the ownership. And focusing on form in lieu of substance is reversible error. So that is one perhaps index of ownership, but that has to be looked at in the substance of the entire package of the ownership and what is really going on as between the tenant and the landlord.
The other thing I struggle with, you spend a lot of time in your brief talking about perpetual dominion or passive dominion. But what strikes me is that in 2025, if there's not another lease agreement, that the REIT has locked the doors and you would not have access to that building. You may have a right of first refusal, but why shouldn't that, why do you have perpetual dominion over this property if they can lock you out in 2026?
Well, Your Honor, I think that is an entirely implausible scenario. The landlord is not just the owner of the building. The landlord is a real estate investment trust. It has a fiduciary duty to its investors to have that property generate income, to give a return of and a return on the investment that the REIT's investors have made. So the landlord doesn't have, morally, ethically, and probably legally, doesn't have the ability to just decide to lock the doors. The landlord's got to go find a tenant for the building to generate revenue. And at that point, that's exactly why Advent Health has total perpetual dominion over the property. There will be a tenant for that building. But if that tenant ends up not being Advent Health will step in. They have said it from the very beginning. That is the whole purpose of Advent Health having the building be built, was so that Advent Health could use it for its purposes, for its medical outpatient services, literally next door to its inpatient hospital. And it has no intentions or willingness to even contemplate that any other medical providers are going to be in that building for the remainder of the ground lease. And I would point out a lot has been made by the appellees that the office lease itself, the lease of the building as opposed to the ground lease. Ground lease is 60 years. The office lease is only 10 years. The reason for that is simply the recognition by the parties that you can't set rent for 60 years and expect it to be fair to both parties. There has to be a point in a long-term office usage like that where the parties are forced to sit down and adjust at least the rent, perhaps some other contract provisions as well.
Isn't it very common in commercial leases to have multiple extensions at market rate and then that's determined at the time? Couldn't you have done that?
Well, they could have, but they didn't. I think from a standpoint of the documents, the right of first refusal is enough to protect Advent Health. They know that their landlord's not going to be a competitor. The landlord is going to be an investment trust. And that's just the market. That's the way that medical institutions like Advent Health do financings of buildings like the medical office building. That's a fairly frequent, common way to do things. And the appellees made note of that the previous landlords have sold not just this medical office building, but portfolios of medical buildings really around the state of Florida and maybe around the rest of the country. When they've liquidated, they've sold numerous of them. So it's a common commercial practice to do things this way. You're not going to end up with a tenant who is not an investment trust of some kind. That's there only to make money, not to actually ever use the building. So the result is Advent Health, unless you just focus on the form, Advent Health in the substance of what's going on and the underlying commercial realities of this financing and this construction, Advent Health has perpetual dominion because it is set up so that there will be a tenant in the building and Advent Health will preempt any other tenant that a landlord may think that he or she can bring into the building. Advent Health has that power. They can lock down their power to control every square foot of that building throughout the remainder of the ground lease. That's perpetual dominion.
Which in the remainder of the ground lease extends beyond what is the expected useful life of that building, correct?
True, but again, Your Honor, in the substance of the ownership, Advent Health, if you look at the cases such as 1108 Areola is cited in both briefs, the courts say that the party will not have, the party that enjoys the useful life of the building is the equitable owner of the building. Advent Health is going to enjoy every bit of the useful life of that building from now until the end of the ground lease, and then they will enjoy it in perpetuity. There's no notion that somehow Advent Health is going to get evicted. If there was some reasonable scenario where Advent Health might get evicted and some other tenant would come in and keep the building for the next 30 or 40 years, perhaps, but there is no reasonable scenario where that's going to happen. And looking at the substance of the ownership, that's exactly what's going on. Advent Health is going to, they control that building now, and they have every right under the ground lease to continue to control it. The office lease terminates only for the purpose of the parties to renegotiate the rents based on the change in market. I would also like to just bring up a second major factor in the equitable title analysis that was ignored by the trial court is the thing that was brought up in the case of Russell versus Southeast Housing, and that's that the reason, and the court explained this really well, the reason that equitable title even exists in the law is because there are times when there is a paper transfer of title, but not for the purposes of actually transferring real estate interests, ownership or interests. It is for some other purpose. That is exactly what happened here. There is extensive testimony which we've cited and quoted in our briefs, which the trial court ignored, and that's that in 2007, Advent Health spent over a year working through the process, the business decision process of how they were going to structure the financing and the construction of the building. And we had extensive testimony from the man, Todd Goodman, who was CFO at the time, who said Advent Health has a capital model, a discipline that they follow in order to preserve their capital. It gets a little complicated. I don't really understand it, but that was the reason, as the Russell court said, the coherent reason why they entered into this. The CFO testified, we would have loved to have just written a check and built the building, but we have a capital model. We have a discipline that we follow. And for the courts have to recognize that. That is why this whole ownership structure of the medical office building is set up that way. It was for a reason entirely separated from the notion of transferring a real estate interest, which takes you to the two cases that the trial court and the property appraiser rely heavily on. The Hertz rental car case and the Broward County versus Eller Drive. Just very quickly, in Hertz rental car, the Hillsborough County Aviation Authority gave a lease of land to Hertz, and they built what rental car companies always do on airport. They built a rental car facility. They had a lease for 25 years. There was no right and no interest on the part of the Hillsborough County Aviation Authority to have any ability to come in and lease any of that property. The case is entirely irrelevant to this case for that reason. The similarities stopped at the ground lease because there was no notion that the Aviation Authority was going to take down any of that property. Same thing with the Eller Drive. It was the Port Everglades Port Authority leased land to Eller Drive Partnership, which is an office building company. They built their office building, but the Port Authority had no right and no interest in reserving any right whatsoever to take down any of the space in an office building. Both of those were the opposite of what I just described. They were real estate transfers purely for the purpose of transferring the real estate and not for some other purpose. It was purely a real estate transfer with no other purpose in mind. There were a number of other misstatements and mischaracterizations of the burdens and benefits of ownership that we brought out in our brief. But what I'd like to finish with is just a brief mention about the Solomon versus Shands Teaching Hospital case. A case that came out in the first district, an opinion was issued in December of this year after we had filed our initial brief. It's an interesting case. It was actually a group of medical office buildings that were located, just like this one, on the campus of a hospital, Shands Teaching Hospital in Gainesville at the University of Florida. The University of Florida, which is an arm of the government of the state of Florida, had gotten the title to those medical office buildings, actually deeded the title, not just leases, but the title had been deeded over to two corporations, but eventually it ended up with something called the Florida Clinical Practice Association, Inc. The Alachua County property appraiser said that's not an immune entity. Taxes have to be paid on those medical office buildings. Both the trial court and the first district said no. The equitable title to those medical office buildings is held by the state of Florida. And the biggest reason, there was a lot of analysis, but the biggest reason I think was clear, and that's that the first district said the state of Florida, acting through the University of Florida, has the right at any time, and they didn't use the word perpetual dominion, but they may as well have. The University of Florida, on behalf of the state of Florida, has the right at any time to reach out and grab the deed and pull it back and take the property, deed to the property, title to the property back and put it back in the University of Florida, which means that the perpetual dominion over that property is held by the state of Florida, and it, of course, is immune from property taxes. It's a very important case. It's extremely relevant to this case. Not only in the facts, but in the fact that there was no lease, there was no financing, there was nothing but the state of Florida decided for its purposes to put title to those buildings into that corporation with the ability to pull it back anytime that that the university chose. With that, I'll go ahead and come back and rebuttal. Thank you.
May it please the court, my name is Lauren Levy. With me today is Kevin Ashley, who represents the tax collector. Mr. Ashley has worked with me on filing just one brief before this court, so a separate brief, and has allowed me to present the oral argument today very graciously, and I appreciate that. I want to start with a couple of just kind of foundational things in property tax, if I could, because this benefits and burdens test can get a little fact specific sometimes as you wade through it. And the first one that I always start with is that the Florida Constitution requires taxation of all property, real and tangible, unless it's expressly exempt, and that's also echoed in the statutes. And then for our charitable exemptions, religious, et cetera, we have a requirement in the statutes that the legislature put in place that the property has to be owned by an exempt entity and used for an exempt purpose. And that is very frequently misunderstood, if you would, by taxpayers. And, oh, we're using the property for church, but yeah, the space is a commercial strip center, you know those types of questions. And so here, there's no doubt that the writ or some version of the writ during time SB2 or the other two writs held the title to the property. And so we stop there, then the property would be taxable. But that's not what you do in tax law, because we have this concept of equitable ownership, which is not a unique or oddity, if you would, in either state tax law or federal tax law. Because basically the acknowledgement has been for many, many decades that if we're just going to strictly focus on the form of the agreements, there are going to be lawyers that are going to outsmart the taxing system and create things that for one purpose should get them out of taxation or limit their taxable status and have other purposes also. And so that concept stems from the United States Supreme Court. The Florida Supreme Court has picked it up way back in the Bancroft case and has moved it on forward. And equitable ownership really just asks property appraisers to decide who is the true and real owner. Put the basket of everything that's going on here, try to evaluate it in substance and say who is the true or real owner of this property. You asked Judge Nordella about the majority of benefits and burdens, or most of the benefits and burdens. Several of the cases use the phrase virtually all of the benefits and burdens. It's not uniform throughout, but I just wanted to point that out. And so when the property appraiser looked at this, and when the trial court looked at this issue, they looked at what was the, how we phrase it, as the commercial and economic reality of the transaction. What is really going on? What is the representations that have been
Let me
made?
ask, can the REIT, what do you call it? REIT? Hardly pronounce it. Can it sell this building without the consent of Advent Health? Adventus Health?
Yes, it can sell the building without the consent of Advent Health. Now, Advent Health has a right to match the sale price and buy the building itself instead.
So in other words, Advent Health can't say, well, you guys have got a buyer for $1 billion. We're never going to match that, but we veto your ability to sell to company X for $1 billion. For some reason, company X has billions of dollars to spend. They want to buy a building in Bartow, no disrespect to Bartow or Sebring, for $1 billion.
Correct.
Advent can't come in and say, you know what, you guys are the technical legal owner of the property, but we're the actual owners, and we're not going to allow you to do that.
No, sir, they don't have that ability. In fact, the record in this case would show that the property twice sold. So Advent Health was twice approached. Would you want to buy the property for the negotiated price? And Advent Health said, no, it's too much.
I mean, because it would seem to me, indicia of who is the quote owner is if one person can veto the other person's ability to sell the property to anybody, then the vetoer is really the owner, because, it's like my kids can't tell my wife and I that, we don't want you to sell the house because we'd like to have that nice lake house when you both die, and therefore don't sell it to, whoever. Then they sound like they're the ones who run the show, or who are the quote owners of the property.
Right. I certainly
If my
follow you
wife's
there.
watching, that doesn't have anything to do with what goes on here, but yeah.
And I would also note in connection with those two sales transactions that Advent Health executed legal documents that were recorded in the public records. It says that, yes, the entity selling the medical office building is the owner of the medical office building during the term of the lease, and we acknowledge that, and we allow the assignment of the ground lease. So, there's several places in the briefs where both the trial court and the property appraiser are accused of elevating form over substance. I just don't think that's borne out by any measure, looking at any of the records below or the factual records. The property appraiser in the denial squarely addressed the equitable ownership issue. The trial court addressed the equitable ownership issue and understood that their tasking was to look at the substance of this transaction and not just the form of the transaction. I did want to go through what I would consider to be the significant benefits and burdens here, if I could, just kind of a laundry list. Obviously, the REITs, and I don't know how to say it either, but obviously the REITs have the right to sell or otherwise convey. They have the right to receive rents from tenants, and they have the right to mortgage the property. I think those three are very, very important indicia of ownership. They also are allowed to place this asset on their financial records and depreciate it. In fact, the REITs advised the SEC and their investors that these were owned assets of the REIT. There's a right to receive eminent domain proceeds. If the building is taken, the REIT has the right to the eminent domain proceeds. Advent gets eminent domain proceeds as a tenant, whatever lost to the tenant. And likewise, these REITs also have the risk, if you would, of incurring the rent loss if there were a vacancy. That's also a very significant burden of ownership. There are some other burdens, and I just ask you to be careful when you go through them. There are burdens placed on the REIT and the ground lease, duty to maintain and repair, insure, pay taxes, that are then via the office lease transferred to Advent Health, much like any triple net commercial lease. And we would not think that those burdens would result in a determination that Advent Health is the equitable owner. In fact, we think when you go through and look at this entire transaction, that They did exactly what the trial court found and exactly what the property appraiser concluded, was that they set up this transaction for the RIT to bear all the risk of building and holding and owning the medical office building during the term of the lease, and they preserved themselves the right to buy that building at some point in the future if they so chose, and an option to purchase or to match someone else's offer. One of the cases that's talked about a lot is the Hartsfield case. And I want to put that together with a lot of other, what I would call, Mr. Wilkes kind of ended up with sometimes paper title is placed in an entity for purposes other than transferring ownership. Well, Hartsfield is one of several cases involving certificates of participation, where the mechanism, the bond issuance and the security via the bond and the certificates of participation require that you place title, bear legal title in an entity that just holds that, serves as a conduit for the rent payments being made through to the bondholders. And once that obligation has been repaid, then it simply transfers title to the entity that's been paying the rent the whole time. But it's at the start created as a shell entity or a conduit entity just for that purpose. And you'll see a lot of those cases. Another way to look at them is bare legal title cases. I always go back and I'm trying to get myself oriented. The best example of a bare legal title conveying equitable owner, or when someone holds bare legal title and is not the equitable owner, is a contract for deed. I'll keep the deed. When you pay off the deed, I give you the deed.
So in essence here, though, I mean, to alleviate the concern of Adventist Health, they could simply go to the REIT and say, okay, not for nothing, we just went through this oral argument. You guys need to deed this building to us. So we are the bare legal title holder, and then we'll be the equitable title holder and the bare legal, and then we'll come to these guys over here and say, okie dokie, we sat through this July 27 OA, and we're going to fix this problem right away and and then they would qualify for the tax exemption, I assume.
Yeah.
Assuming the other qualifications that you outlined in the council.
Yes, sir. I believe
And that would end the discussion going forward.
Yes, sir. It would.
At least from your guys' standpoint, you wouldn't have a leg to stand on. Or,
they would be
what
entitled.
analogy you want me to use?
Well, they would be entitled to the exemption because it's a charitable hospital, and the use would be charitable.
Counsel, in your answer brief, I don't think you had the opportunity to address the Solomon versus Shands case. Could you do that in your time today?
Sure, I certainly can do that. And I think when you go through and read that case, there is a significant and lengthy discussion of the interaction that Shands and the Practice Association, FCHA, I think it was, how they are intertwined and controlled by UF School of Medicine. The School of Medicine and UF through the Board of Trustees make all decisions whether to buy, sell, convey the property, and make all decisions as to how the property is going to be rented. There is just a lengthy discussion of all of the intermingling, if you would, of these entities for the purpose of holding title. And so when you finish reading the case, for example, one of the entities had no employees of its own. All of its employees was through the College of Medicine. The other entity is Shands, which there's a long line of cases in the liability context dealing with the interaction of Shands and UF and the entitlement to sovereign immunity, things like that. And so the court found that Shands and this other entity were owned and controlled, and all real decisions involving the property were made by the Board of Trustees and the College of Medicine. And that's simply not what we have here. The RIT owns and controls this building. If someone comes along and wants to buy it at a fair price, the RIT says, I'm going to sell it to you. And Advent would have the right to come in and match that price if they so choose.
But the office lease here certainly gives a lot of burdens and benefits as opposed to the ground lease. What do you make of the argument that the trial court failed to consider both?
I don't believe so. It was extensively argued, both aspects of it, and our point on the office lease was it bore all the hallmarks of a triple net lease. And if a triple net lease converted every lessee to equitable ownership, we'd have quite a foundational change in our property tax structure is where we would be with that. So we don't believe that those burdens would, and if you were to weigh those burdens, would outweigh the other benefits of the ownership of this property that the writ had. I wanted to mention or talk 1 minute, if I could, about the perpetual dominion argument. When you go back and look at those cases, the Island Authority cases, Santa Rosa Island, which has been in litigation for decades, and you look at the Supreme Court decisions and the First District Court of Appeal decisions there, you had two decisions come out at the same time. One involved the land in Santa Rosa County. The other decision involved the improvements in Escambia County. For the land in Santa Rosa County, the court found that the leases in Santa Rosa were for 99 years, renewable on like terms for another 99 years, subject to further renewals, and found that that was essentially a perpetual lease, giving the lessee perpetual dominion, and therefore the land was taxable. In the companion case dealing with just the improvements, the court notes, well, our case in the land and for the land turned on the fact that the leases were perpetually renewable. But the oddity factually in Escambia County is that the leases there were for 99 years with an ability to renegotiate upon mutually agreeable terms between the parties. And the court said that's not perpetually renewable. Okay, that's different. They carved that difference. 99 years renewable on like terms for another 99, that's a perpetual. 99 years renewable upon mutual renegotiation of mutually agreeable terms and conditions, not perpetually renewable. But then it went on in that case and said, but the improvements, because the economic life was far less than the term of the lease, were owned by the lessee. And therefore, equitable title and the lessee property appraiser had it properly on the tax roll. So then two other cases come through the first DCA, both dealing with just land. And the first DCA both times points out the distinction in the lease term between renewable upon like terms and renewable upon negotiation. The release we have here, and I said all that to get to the lease we have here, the 10-year office lease simply expires at the end of the 10 years. The only right you have is to try to renegotiate that term of lease. If you're unable to renegotiate it at appropriate terms, they can lease it out to other tenants. Now, there are some conditions in the ground lease about Advent had some say over who the tenants were, but if you couldn't get it leased up sufficiently, the writ had the ability to lease it to whoever. So to say that we're going to have perpetual dominion because, and what they rely on that is an affidavit from their client that they would intend to renew, or they would be likely to renew the office lease. Certainly the lessees at the Santa Rosa Island that have their house on the beach in the 99-year lease, they are likely to want to try to extend that lease too. But the court has said that's not perpetual renewals or perpetual dominion. So I think their argument in that regard falls well short. And actually, I think that the writs have far more indicia of ownership and benefits and burdens than does Advent Health in this case. And I think when you go through all those cases, you can kind of put those in the same. There's a good number of cases that I would call bare legal title or COPS or certificates of participation cases, or for some financing mechanism, you put bare legal title in an entity as security until a debt is repaid. The last case I want to talk about is Russell. I think what's significant in Russell was that the Navy and a private entity jointly went together and formed a new entity, Southeast Housing. The Navy put in $75 million. Private entity put in $7 million. Percent went to the private entity, the rest went to the Navy. Financing was repaid, the Navy became the owner of the property at the end of the term. That's much more similar to the idea that we had in the Crapo case, which is kind of another University of Florida case cited in the briefs, where you would create an entity there. It was a single member LLC for the purpose of holding the student dorm. You're creating an entity solely for the purpose of holding title to facilitate the transaction. And what the Russell court said is, well, hey, they put legal title in this entity for two reasons. One, so they could issue bonds, and two, so they could charge rent as a private entity that they would not have been able to otherwise charge as if they were the Navy. And they kind of commented, now that's kind of circumventing the federal rules, but that's not really what's going on here. What has happened is they placed title in this entity. This entity is entitled to none of the rents and cannot sell the property. And at the end of the term, the Navy becomes the owner of the property. Again, that's far from what we have here. We don't have any shared ownership or formation of an entity by which two parties are going to be involved here. So we would very respectfully request that this court affirm the trial court's summary judgment. Thank you.
May it please the court, just to, in response. Mr. Levy is misstating what the law is on things like the burdens and characterizing them as a typical triple net lease. There is nothing in any of the case law that says when the courts and the property appraisers are to weigh the burdens and the benefits of ownership, but don't pay attention to any burdens that might be part of a commercially frequent triple net lease. There's none of that. The burdens in this case, in the ground lease assigns a tremendous number of burdens to the building landlord. But then the office lease, where Advent Health took possession of the entire building, shifts every one of those burdens back to Advent Health. And to trivialize that and to say that that doesn't count in what the courts say, the courts that is supposed to be done, analyzing the burdens and the benefits, to trivialize that and say, well, that's just what happens in every commercial triple net lease. There's no case law for that. There's none whatsoever. Secondly, to add again to, he speaks with some frequency about how Advent Health relies on an affidavit of one of its chief financial officers that it intends to keep control of the medical office building. And that affidavit's not enough. It's just a statement of intent. The court wrote that that statement of intent has no legal significance. That is part of the substance of the ownership. That speaks context to why the ownership is set up the way that it is, why the leases are set up the way that they are, why Advent Health has the right of first refusal, which gives it the ability to control that building in perpetuity. It gives it the ability to control the building for the remainder of the 60-year ground lease, and thereafter it has the building free of any interest on the part of the landlord. Interestingly, this 60-year lease, at the end of the lease, it's not the tenant that gets evicted, it's the landlord that gets evicted. Now that's not just an ordinary commercial triple net lease. When the landlord is sent on his way and the tenant stays, well, what's going on there? It is an issue of equitable title. It is where paper title, in this case, paper leasehold, was transferred for a reason other than just granting a lease to the landlord. He spoke about the fact that a lot of these cases are like the Hartsfield, Leon County Educational Facilities Authority versus Hartsfield, where they issued COPS, and whenever the lease payments paid off the debt, then the Educational Facilities Authority got title back to the dormitories and the cafeterias that they had built for the universities in Tallahassee. Well, that speaks again to the substance of the ownership. There's nothing that says that unless you match the facts of Hartsfield, you're not engaged in the substance of an equitable title type of financing. And in fact, Solomon shows that. Solomon had no financing whatsoever. There was nothing, no payback during which, or the point at which the UF would get title back to all of the medical office buildings on the Shands campus. There was none of that. UF had the opportunity to reach out and just pull the title back. Solomon made the point that the appellees in that case, or the appellants in that case, trying to just distinguish that case from every other reported court case. The first district rejected that and said, those court cases, which were the three that we have been cited, those court cases provide support for the University of Florida and for Shands, and we're fine with that. Thank you, Your Honor.
Thank you, counsel, for your time today. It was well argued. We will be in recess until 11 o'clock.